Hi, in this video we are going to take a look at a reading comprehension passage which was once asked in a law entrance examination. The directions as usual say, the questions in this section are based on the passage. The questions are to be answered on the basis of what is stated or implied in the passage. For some of the questions, more than one of the choices could conceivably answer the question. However, you have to choose the best answer, that is, the response that most accurately and completely answers the question. Now, in the exam, I would recommend that you read the questions before so that you get a sense of what you're searching for in the passage. In this video, I'm going to read out the passage and then do the questions individually. You can pause the video now to read the entire passage on your own. The Constitution of the United States protects both property rights and freedom of speech. At times, these rights conflict. The resolution then requires a determination as to the type of the property involved. If the property is private and not open to the general public, the owner may absolutely deny the exercise of right of free speech thereon. On the other hand, if public land is at issue, the First Amendment protections of expression are applicable. However, the exercise of free speech thereon is not absolute. Rather, it is necessary to determine the appropriateness of the forum. This requires that consideration is given to a number of factors, including character and normal use of the property, the extent to which it is open to the public, and the number and types of persons who frequent it. If the forum is clearly public or clearly private, the resolution of the greater of rights is relatively straightforward. In the area of the quasi-public property, balancing these rights has produced a dilemma. This is the situation when a private owner permits the general public to use his property. When persons seek to use the land for passing out handbills or picketing, how is a conflict between property rights and freedom of expression resolved? The precept that private property owner surrenders his rights in proportion to the extent to which he opens up his property to the public is not new. In 1675, Lord Chief Justice Hale wrote that when private property is affected with a public interest, it ceases to be private. Throughout the development of Anglo-American law, the individual has never possessed absolute dominion over property. Land becomes clothed with the public interest when the owner devotes his property to a use in which the public has an interest. In support of this position, the chairman of the board of the Wilder Lake Shopping Center in Columbia, Maryland said, "The only real purpose and justification of any of these centers is to serve the people in the area, not the merchants, not the developers, not the architects. The success or failure of the regional shopping center will be measured by what it does for the people it seeks to serve. These doctrines should be applied when accommodation must be made between a shopping center owner's private property rights and the public's right to free expression. It is hoped that when the court is asked to balance these conflicting rights, it will keep in mind what Justice Black said in 1945. When we balance the constitutional rights of owners of property against those of the people to enjoy First Amendment freedoms, we remain mindful of the fact that the latter occupy a preferred position." So as you can see, this is a passage with a legal background. It talks about weighing the individual's right to property against the freedom of speech. Law aspirants would do well to read this passage a couple of times to understand how explanations are given about juxtaposition of two different rights. Let's take a look at the questions. The first one. In which one of the following cases would the owner of the property probably be most free to restrict the freedom of speech? Now, the passage tells you that the extent to which the freedom of speech has to be given is the extent to which the owner has allowed the public to access the property. Let's see how which of the following examples is where the owner is allowed to restrict the freedom of speech. That means we are looking at minimal public intrusion on the property. First, an amusement park attended by 5 million people each year owned by a multinational company. Well, 5 million of the public attending the property, that's a large number. A large amount of public is coming here. A small grocery shopping mall owned by a husband and wife. Now, although the mall is owned by a husband and a wife, because it is for grocery shopping, a lot of general public is free to visit here. So again, this is open to a lot of public. An enclosed shopping mall owned by a single woman. Again, a shopping mall is a public property, and although owned by a single woman, a lot of people would be free to come there. So again, it is open to the public at large. An 8-unit residential apartment building owned by a large real estate company. Now, a residential building is limited to the people living there. It is not open to the public at large. The first three is pretty much open to all and sundry public. The fourth option, a residential apartment, is not open to everybody. It is limited to the people who live there. So technically speaking, because this has the least amount of access given to free public, this is where the owner of the property can have maximum restrictions on freedom of speech. So option D would be my best choice. The second question, a conflict between property rights and freedom of speech might arise in all of the following situations except. So we have to take a look at the option where there is not much of a conflict between property rights and freedom of speech. Okay, first one. Protesters carrying signs outside a cinema in an enclosed shopping mall. Well, protesters, freedom of speech, property rights of the shopping mall, definitely there is a clash between the two. Second, a disgruntled or unhappy employee passing out leaflets in front of a hairdresser's salon. Well, a hairdresser's salon, if construed as private property, then the disgruntled employees passing out of leaflets is free speech. Again, there is definitely a conflict between the two here. A religious order soliciting funds and converts in the swimming pool area to a condominium. Okay, a religious order soliciting funds and converts in the swimming pool area of a condominium. A condominium is nothing but a set of bungalows for people. Now here the individuals are asking for funds, right? But it is not harming anybody. In the first and the second option, a protest or an unhappy employee passing out leaflets would lead to problems. Third one, it's just a religious order people begging for funds or asking for donations. So that does not seem to be very controversial. Let's take a look at the fourth one. A candidate for mayor handing out flyers in front of his opponent's headquarters. Okay, if you are doing something in front of your enemy, your opposition's place, then definitely a conflict. So A, B and D are situations where potentially two people would have objection to the person saying something and exercising freedom of speech. But the third one does not seem to be too much in conflict. So in 4 options, the best one here would be option 3. The third question. According to the passage, an owner's freedom to deny freedom of speech on his property is determined by all of the following except. Well, here we are asked to evaluate the rules. So you'll have to read the passage very carefully. Let's take a look at the one of the option which does not, I repeat, does not determine the owner's freedom of speech. So first, whether or not the land is open to the public. Clearly, as seen in the first 2 questions and from the passage, this clearly tells you whether there is a freedom of speech or not, and whether the owner can deny it or not. So one, not my answer. Nature of and usual use of the property. Definitely this will define whether freedom of speech can be denied or not. Type of persons who frequent the land. Correct. If the general public is allowed to come to the land, then it is general use. So yes, that does matter. Fourth, nature of character of the owner. Well, here it does not make any difference. What is the character of the owner? How is the owner? That does not make a difference. So from the 4 given options, the 4th one, nature of character of the owner, does not determine the right to deny freedom of speech. So option D is the best one. 4th one. We can infer from the passage that the author believes that shopping malls in America, okay, now clearly it is written where he says it is not in favor of the owner, not in for the architect, and so on and so forth. So definitely option A should be in service of the people who frequent them. The ordinary paying customer is definitely the right answer. Let's take a look at the other options. The nature of and usual use, have a right to prohibit distribution of advertising handbills? No. Have a right to control distributed material? No. Should permit any charitable solicitation? No. clearly from the passage we can say where he clearly indicates that it is for the people who are frequenting them and not the others. So option A definitely my right answer. Fifth question. According to the passage, the idea that a property owner's rights decline as the property is more used by the general public. Towards the end of the passage, it does very clearly point out that the more a person uses it, the less it gives the owner the right to deny. So, is peculiar to recent Supreme Court decisions? No. Attested by a 300-year-old opinion? Well, clearly it does mention that. Go back to the passage and check it. Conflicts with the idea that property affected with a public interest ceases to be private? No. Is now universally accepted in Great Britain and Canada? We have no mention of these countries. So best possible option is definitely option number 2, the second one. The sixth question. All other things being equal, the courts must watch. What? Okay, the very last line tells you the latter is preferred. Remember that? What is the latter in that sentence? Go and check. So the first one, favor the First Amendment rights over property rights. Definitely true. Favor property rights over First Amendment rights? No. Treat property rights and First Amendment rights equally? No. Protect property rights of the owners? No. Very clearly from the last line in the passage, you can make out that option A is the best possible answer for this particular question.